Welcome to U.S. Immigrant Journey, Opportunities and Challenges.
Hello and welcome to U.S. Immigrant Journey, Opportunities and Challenges with Attorney Edwin Fogam. With over 25 years of experience in immigration and various areas of the law, Edwin brings a wealth of knowledge and a global perspective to his practice. I am your host, Kevin Rosenquist, and today's episode is Family Immigration Court, How to Prepare. Edwin, welcome back.
Thank you, Kevin. How are you?
I'm great. I'm excited to talk to you again, and this will be an interesting episode because we haven't talked about immigration court yet. What are some of the common reasons family-based immigration cases are referred to immigration court?
Actually, not only family-based, both even employment-based could be referred, but generally, these removal proceedings or deportation proceedings are initiated usually by denial, right? A denial of the petition. And USCIS denies a family-based petition. Depending on the status of the applicant and depending on other factors, they could initiate removal proceedings by what is called a notice to appear that refers that applicant or that foreign national to immigration court. And that begins the process for an immigration court proceeding.
What do you tell people? How can families avoid these situations? What advice do you give?
Well, there are a couple of things. First of all, make sure your petition is approved.
It's a good starting point.
Yeah. If your petition is not approved, try to take the next possible things to do, like motions to reopen and reconsider, appeals, and consider other immigration strategies, such as changing your status if possible. Because if you are in a valid non-immigrant status, you cannot be placed in proceedings. In fact, that stops proceedings.
What can you kind of explain the steps involved in a family immigration case that goes to court and what people should people should expect during each stage?
Let's take an example. Let's take a family-based spousal petition where a U.S. citizen has filed for his or her spouse and they're both in the United States. They schedule an interview. After filing everything, going through the interview, that doesn't go well. What will happen is they will receive a denial letter, and after that, they will receive something that is called a notice to appear, which is going to place them in removal proceedings. That notice will say things like, you are a foreign national, you came here on this time, you are not in valid immigration status, and you should appear to say why you should not be removed, and so on and so forth. That's an example in a family case situation. Situations like political asylum, an affirmative application for political asylum. If it is not granted, you will be referred to immigration court.
Okay, so then what? So you have to appear. You get to court. You've got Edwin on your side. Then how does that process sort of unfold from there?
Well, yeah, generally. There are two hearings in immigration court. You have an initial hearing that is called the master calendar hearing. That is it's more or less a preliminary hearing where the attorney appears with the client or the client appears by themselves, and you have to say why you should not be why you should not be deported. You give what is called a relief or something you are going to apply for if you have one. After that, the judge will give some time and there will be a scheduling order telling you the things you have to file with the court. If you qualify for certain applications, you will have the opportunity to provide those things to the court and submit additional documents and things like that. Now, after that, a second hearing will be scheduled called a merits or an individual hearing. And that is where you appear in court and actually provide testimony and be cross-examined by both the judge and the government to determine whether you actually qualify for the relief that you are seeking, whether you qualify to meet the requirement not to be removed. That hearing can be complex, it can be simple, depending on the type of case. Some can go for 4 or 5 hours, some can be just about an hour. So it's a whole process.
Is there an immigration judge that decides the outcome of the case?
Yes, most generally immigration courts cases are determined by the immigration judge. The judge hears the case. The government, DHS, have their attorney who presents the government's position, right? Most of the time opposing. And based on the documentary as well as testimonial evidence and other things, the judge enters a decision, giving the foreign national the relief that they requested, that they seek, or ordering that person removed or deported from the United States.
What kind of factors do the judges look at?
Testimonial, credibility, testimonial evidence and the credibility and the demeanor, and there are corroborating evidence. There are things that are called corroboration. What type of documents have you submitted? For example, if it's a marriage case and you're saying you guys have a good faith marriage, what are the documents that establish that it's a good faith marriage? Do you have bank accounts? You have proof of lease, shared life together, and things like that. For asylum cases, you may need to submit documents relating to your testimony. What happened to you? How do we know this happened? Were you treated? Did you go to the hospital? Medical records and sworn statements, affidavits. Sometimes you could use experts too in certain situations. If the country conditions are in question, you may need to call an expert, and sometimes psychological experts to determine the traumatic situation that you went through, if you had gone through something in your home country that you want the court to understand, and so on. So there's a lot of things you have to do. Cases differ.
What are some of the common mistakes you see families make when they're navigating immigration court proceedings for family-based visas?
The first big mistake that I see a lot is failure to appear in court.
That's not going to help you.
Yeah, some people receive notices to appear and they don't go. And sometimes just other simple things like change of address. When you file your immigration, you don't change your address and your notices are sent to your previous address, you don't get them. Then what happens is the judges will enter you deported in your absence. So you would have been ordered deported, but you don't even know it. So walking around, you'll be arrested. Also, the mistakes many people in removal proceedings make is they don't start early to prepare the substantive documentation to support their cases, because many times it takes a while to put all the documents together and to file your application. The court usually gives a lot of time after the master calendar or initial hearing. They give you depending on what you ask for, what the lawyer or the client or the applicant ask for. They'll give you the time to put those documents, and sometimes people don't do that. Also, people don't prepare for the actual hearing. There are things you can do to prepare for that hearing. You have to know your testimony very well, be ready to respond to cross-examination questions from the government regarding your testimony and things like that. So all those mistakes are they are rampant, to say the least.
So when someone's case is, when their immigration case is rejected in court, pretty much that means you're going to have to leave the country.
Well, that is what the order says, that you should leave. But usually, most of them will have a 30 days period if you want to appeal. You can also file a motion to reopen and reconsider before the same judge, right? But many times that is futile because the same judge, a conclusion, I don't see how within 30 days, many of them, they're not going to change their minds, right?
Yeah, and what kind of evidence are you going to find in those 30 days that would change his opinion, right? That
is the challenge with that. But you could always appeal to the Board of Immigration Appeals. And many times, especially there are certain cases where the board has remanded cases based on error, the judge's error, when the judge failed to recognize certain facts, or based on the record, the judge made some mistakes. Say, for example, the respondent is credible, but at the same time, not accepting certain aspects of the claim and denying the petition. So sometimes they do that. So an appeal is something that I always encourage, especially if the case was originally strong and you think that this decision is very subjective, doesn't really stand based on the evidence. It's important to appeal your decision.
What role does a business immigration attorney play in supporting family-based immigration cases that do go to immigration court?
Well, first of all, Kevin, I'll tell you that I think it's a misnomer to say business immigration attorney, because the nature of immigration is such that a family-based business immigration, I know it is some attorneys specialize or do more of businesses than family or court and other areas, but the nature of immigration, to really represent clients in immigration matters, you need to have very broad understanding of the various aspects. But to answer your question, an immigration attorney who is focusing mostly on business can actually assist their clients in immigration courts because it depends on what they are in there for. Most applications are not appealed in immigration. They don't refer them to immigration courts, right? When they are denied, they would be denied based on either, so the appeal goes to another unit, an administrative office. However, if your employee's application was denied and your employee is out of status and they are placed in removal proceedings, that is where the employer can help, along with the business immigration lawyer. You can help that employee to find options, other strategies that can be a relief from deportation. Does that make sense?
It does, yeah, it does. What is your advice that you give to families going through immigration court proceedings to best prepare for the process and increase their chances of a successful verdict?
There are a couple of very obvious things, of course. First of all, get a good attorney or somebody who can understand what you are going through and can actually help you. Some people have represented themselves in removal proceedings in court, but it's quite risky, but that can be done. Secondly, start early. As soon as you are referred to immigration court, let somebody look at your papers to start creating a strategy, because you have to documents, maybe you have to see a psychologist, maybe you need an expert and things like that. And thirdly, you have to prepare for your hearings. Preparation for the hearing doesn't mean you just read it or you just sit down and so. No, it actually means going through questions that will possibly be asked of you over and over. We meet with our clients 3-4 times before hearings.
Wow.
Because yes, each time you meet, you hear more things and things like that. So if and when you are well prepared and having submitted substantial documents, you increase your chances of being granted the relief that you are seeking.
Yeah, I guess it sounds to me it's not different than any other preparation for trial. You're getting someone ready to be cross-examined.
I agree.
Interesting. Yeah, I would imagine that's incredibly helpful for people because it gives them more confidence. It gives them that they're not fumbling around with their words as much. They're giving answers in a more directed way instead of just like kind of meandering around. I mean, like that's got to help tremendously.
Yeah, Kevin, now you are talking like a lawyer. Like a real lawyer.
Fine,
Yes.
I'll work with you, but my salary demands are very high though. I just want you to know.
Okay, all right. I hear you.
You're like me too. All right. Well, thank you for joining us on U.S. Immigrant Journey, Opportunities and Challenges with Attorney Edwin Fogam. To connect with Edwin and his team, head to fogamlaw.com and please like and subscribe to our channel. Edwin, always great to see you. Thanks so much for all your time.
Thank you very much, Kevin. I hope to see you soon.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.